Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps our channel grow. For today's case, we're dealing with a somewhat infamous one in Second Amendment history. This is United States versus Crushank, United States Supreme Court from 1874. In this case, the U.S. Supreme Court basically says the Second Amendment doesn't extend to private rights, and it kind of kills the Second Amendment. That's actually not the major thrust of the case. That particular line is kind of a throwaway line in the overall case. So we're going to cover the case for what it is, and we'll get to the Second Amendment stuff, and we'll cover it as it goes. But for the moment, let's get started with Crushank. This case comes here with a certificate by judges of the Circuit Court for the District of Louisiana that they were divided in an opinion upon a question which occurred at a hearing. It presents for our consideration an indictment considering 16 counts. So first thing here is that we've got a request for a decision before the appeal goes forward. So they want to certify a question from the Circuit Court to the U.S. Supreme Court. It's like, we don't know the answer to this. Would you tell us the answer? Now, certified question is something you can do. It doesn't happen in modern times, at least from the district court or court of appeals to the U.S. Supreme Court. They don't really do that anymore. But they still do it from Supreme Courts to Supreme Courts. So you'll occasionally see one Supreme Court of one state ask another Supreme Court of a different state for something dealing with their law because the first state has some dispute that's before their court but concerns some aspect of their law. So you'll see these certified questions, but not really so much the U.S. Supreme Court, no. Not today. Maybe in 1874, but not now. So here's the law that we're going to deal with. This is the law that's in operation with respect to these potential criminals. That if two or more persons shall band or conspire together, or go about in disguise upon a public highway, upon the premises of another, with intention to violate any provision of this act, with intent to prevent or hinder free exercise and enjoyment of any right or privilege granted or secured by him by the Constitution, there is a fine not to exceed $5,000 and imprisonment not to exceed 10 years. So the long and short of this is, at least in the law that was at play that day, is if two or more people acted in conspiracy to deprive someone of their federal rights, you're going to go to federal jail. Easy enough there. Okay, fine. The general charge in the first 8 counts is that of banding, and in the second 8, that of conspiring together to injure, oppress, threaten, and intimidate Levi, Nelson, and Alexander Tillman, citizens of the United States of African descent and persons of color, with intent thereby to hinder and prevent them in the free exercise and enjoyments of rights. So we got here a couple individuals who may be conspiring and banding, which apparently are distinct concepts in 1874. Not so much today. Banding is really the same thing as conspiracy, so I'm not sure how that works, that you can separate those two, really, but apparently you were able to separate those two in 1874. And anyway, in any case, that these individuals intimidated 2 African Americans in order to prevent them from exercising federal rights. Let's read on. The offenses provided for by statute in question do not consist in the mere banding or conspiring of 2 or more persons together, but in their banding or conspiring with intent for any of the purpose specified. So, as is often the case, it's not merely enough that these 2 people got together to come to some agreement. It must be an agreement specifically for the purpose, the intent, of preventing someone from engaging in their federal rights. So, it's not merely a conspiracy in general, not merely a banding in general. It has to be for specifically this purpose, for this statute. The court continues, we have in our political system a government of the United States and a government of each of the several states. Each one of these governments is distinct from the others, and each has citizens of its own who owe it allegiance, and whose rights within its jurisdiction it must protect. The same person may be at the same time a citizen of the United States and a citizen of those states, but his right of citizenship under one of these governments will be different from those if he has of another. So yeah, that is very true, and that's still true today. Then the 14th Amendment makes this clear. A person is a citizen, if they're a citizen of the United States, they're a citizen of the United States and the state in which they reside. So it is quite proper for me to say, I'm a citizen of Texas. And I am. I'm a citizen of the United States and I'm a citizen of Texas, just surely the same. So yeah, I'm a citizen of two different governments, and they're distinct, and they have their distinct laws, and they give me different privileges. And there are things I can do because of my citizenship I couldn't otherwise do. And the main one that comes to mind most obviously is voting, because I can vote here and not vote other places, but I am protected by the laws of this state and, the United States, and those are distinct things. So, yeah, fair enough. That's the way of law. That's how we work in a federalist system. We have a collection of independent sovereign states, kind of like Europe, but unlike the EU, they're in a tighter arrangement. So it's quite proper to say that there are sovereign states, but that also the national entity is sovereign. You wouldn't talk about the EU as a collective being sovereign. You wouldn't use that word for this exact reason. So that's kind of how that goes. Experience made the fact known to the people of the United States that they required a national government for national purposes. The separate governments of separate states bound together by the Articles of Confederation, which is what we had before the Constitution, and didn't really go that well, to be quite honest, were not sufficient for promotion of general welfare of the people in respect to foreign nations, or for their complete protection as citizens of Confederated States. Yeah, didn't really work out for us well under the Articles of Confederation. The national government was extremely weak. It couldn't lay taxes. It was not going great. And so they, scrapped that and came up with something else that was a lot closer. So the Articles of Confederation were, I suppose, roughly equivalent to the EU. And then we decided we needed a tighter relationship. So then we went to that. The government thus enabled and defended is, to some extent, a government of states in their political capacity. It is also, for certain purposes, a government of the people. Its powers are limited in number, but not in degree. Within the scope of its powers, as enumerated and defined, it is supreme and above the states, but beyond it has no existence. So this stands for the bombshell proposition that our federal government is one of limited powers, one of enumerated powers, one might say, which is the constitutionally correct way of putting it. The federal government doesn't have what's called police power. And that the word police power means basically the general power to do stuff at large. They don't have police power. They have the power to do specific things. And those specific things might be fairly extensive, but they're not the power to do general stuff. General stuff is for states. So in some ways, the states have more power than the federal government, and that is by design. So the federal government only has as much power and much right as it does. Anything that it doesn't have reverts back to the states. Please see the 10th Amendment for that one. So that's federalism. The people of the United States resident within any state are subject to two governments. So you might not reside within any state, incidentally. And if you're a United States citizen living overseas, you know all too well the United States federal government still has jurisdiction over you. So one state and one of the national, but there need not be conflict between the two. The powers which one possesses, the others do not. They establish for different purposes and have separate jurisdictions. True, it may sometimes happen that a person is amenable to both jurisdictions for one and the same act, which is fair enough, because it might violate the laws of both, or only of the one, or of neither. But yeah, it might sometimes violate the laws of both. This does not, however, necessarily imply that the two governments possess powers in common or bring them into conflict with each other. It is a natural consequence of citizenship which owes its allegiance to two sovereigns and claims protections from both. So yeah, I have protections from the United States federal government and protections from the state of Texas, and those are distinct things, and they provide me distinct remedies. And depending on what went wrong, I'd be suing in federal court, I'd be suing in state court, or I'd be being criminally tried before a state court or before a federal court or whatever. But, there's definitely distinct things. And depending on what I want, one government or the other might be the one to go to. So, yeah, that's federalism. The government of the United States is one of delegated powers alone. Its authority is defined and limited by the Constitution. All powers not granted to it by the instrument are reserved to the United States, reserved to the states or to the people. No right can be acquired under the Constitution or laws of the United States except such as the government of the United States has authority to grant or secure. All that cannot be granted or secured are left under the protection of of the several individual states. So the premise here is the United States federal government can't give you any right or give you any security that is outside of its power. And if it's not within its power, then you would be looking to the states, would be your only remedy, which I suppose is true enough, and then trying to define where those lines are is where things get complicated. The First Amendment to the Constitution prohibits Congress from abridging the right of the people to assemble and to petition the government for redress of grievances. This, like other amendments proposed and adopted at the same time, was not intended to limit the powers of state government in respect to their own citizens, but operate on the national government alone. So this is basically rejecting the concept of incorporation, which unfortunately was already decided a year earlier in the slaughterhouse cases, 1873. So, the U.S. Supreme Court really screwed this up in the slaughterhouse cases. And they're not about to reverse it here in 1874, or incidentally ever, because they still haven't reversed it. But yeah, basically they nuked the Privileges or Immunities Clause. It was a perfectly good clause of the Constitution, and the Supreme Court just kind of nuked it out of existence. It's just not really a thing, and even though it's there, so yeah. So basically they say, okay, the Constitution doesn't protect any right you have under state rights. It only protects those you have under national rights, which I suppose is true enough. But then what the scope of those are, it got narrowed very deep. Very deep. It got nuked completely. So the First Amendment is a national right, but not really. So that's kind of the conclusion of the state of law that we're at this point in history. The right of the people peaceably to assemble for the purpose of petitioning Congress for a redress of grievances or for anything else connected with powers or duties of the national government is an attribute of national citizenship, and such under the protection of and guaranteed by the United States. The very idea of a government, republican in form, implies a right on the part of its citizens to meet peaceably for consultation in respect to public affairs and petition for redress of grievances. Okay. And then they get to the part that the gun rights people remember this case for. The 2nd and 10th counts of the indictment are defective. The right there specified is that of bearing arms for lawful purposes. This is not a right granted by the Constitution. And to understand why, you have to go back to the slaughterhouse cases, which I believe we have a video on my channel for, because that's where they kind of nuked it out of existence. Neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that shall not be infringed, but this, as it's seen, means no more than it shall not be infringed by Congress. Which, again, because they nuked privileges or immunities, So the Second Amendment only binds the federal government, despite the Privileges or Immunities Clause, because of the slaughterhouse cases. This is one of those amendments that has no other effect than to restrict the powers of the national government, leaving the people to look for protection against any violation by their fellow citizens of the right it's recognized to what is called, in the city of New York, the powers which relate to merely municipal legislation, or what was perhaps more properly called internal police, not surrendered or restrained by the Constitution. So, the Second Amendment, at least in this time period, protects you against federal action, but not state action, and that's equally true for the First Amendment, as we just read. So, this is not really the state of the law now, as I'm sure you can appreciate. This started changing in 1939. That's how long it took. It took another 63 years after this to change the law. So, way to go, Supreme Court. You kind of screwed up that one. The 14th Amendment prohibits a state from depriving any person of life, liberty, or property without due process of law. But this adds nothing to the rights of one citizen as against another. It simply furnishes an additional guarantee against any encroachment by the state upon fundamental rights which belong to every member as a society. So the 14th Amendment doesn't protect you against what an individual does, which is true in its own terms, I suppose. But then the next logical step is it prohibits Congress from passing legislation that would allow it to prohibit it. So, okay. The 14th Amendment prohibits a state from denying to any person within its jurisdiction the equal protection of the laws. But this provision does not, any more than one which precedes it, and one would be just considered, add anything to the rights one citizen has under another. So, if a citizen harms you, it's not a state actor. So, no 14th Amendment protection for you. And the government, the federal government, having the power to enforce the 14th Amendment doesn't allow them to, at least according to this court, allow them to protect one citizen against another. So, returning to the merits of the case before us, dealing with the criminal indictment, the Supreme Court continues. Another objection is made to these counts, that they're too vague and uncertain. This will be considered hereinafter in connection with the same objection to other counts. Inasmuch, therefore, as it does not appear in these counts that the intent of the defendants was to prevent these parties from exercising their right to vote on account of race, it does not appear it was their intent to interfere with any right granted or secured by the Constitution. We may suspect race was the cause of hostility, but it is not so averred, or to put it in more modern parlance, it's not so alleged. So I don't know whether or not that's true, but okay. So yeah, this is going again to Slaughterhouse. So basically, long story short, the Supreme Court said, okay, the 14th Amendment was meant to deal with slavery. And so it only deals with slavery. It only deals with that, is their logic. Now, I like to take note here that the 14th Amendment doesn't mention anything about slavery. If you want slavery, you can go talk to the 13th Amendment. It mentions something about that. But the 14th Amendment doesn't talk about slavery. But the Supreme Court says, oh, it's only meant to deal with that. So the 14th Amendment only allows the federal government to extend rights insofar as it would be related to slavery. So if you can't show or you can't argue that these individuals deprive this other individual because of race, then it doesn't fall within the bounds of the 14th Amendment. Now, nothing in the language of the 14th Amendment suggests that result. The language of the 14th Amendment seems pretty clear on its own terms. But then again, this is 1873, 1874 U.S. Supreme Court. So that's what they had to say. So that's that's the state of the law there. It was a very, very narrow construction of the 14th Amendment. So you didn't have Second Amendment rights. You didn't have First Amendment rights. You basically didn't have any rights. And the federal government could only do stuff related to the 13th, 14th, or 15th Amendment insofar as it had to do with race and nothing else. Even though the text doesn't say that. Different philosophy for a different time, I guess. We, therefore, are of the opinion that the relative counts of the indictment do not constitute charges of criminal nature that are indictable under the laws of the United States, and consequently, they are not good and sufficient in law. So, a lot of these indictments are not valid because the law is not valid. Then they come to a different provision of the indictment with respect to other charges. They say the intent charged in these counts is to hinder and prevent parties in free exercise and enjoyment of their rights, privileges, immunities, and protections granted to them and secured for them, respectively, as citizens of the United States and citizens of Louisiana. For that reason, they, being there and then citizens of that state and of the United States, were persons of African American descent and race, and persons of color and not white citizens thereof. Okay. According to the view taken of these counts, the question is not whether it is enough in general to describe a statutory offense in the language of the statute, but whether the offense has been described as all. So they are saying that the indictment does not adequately describe the offense. So they're saying it's not a question of would it be sufficient to merely recite the statutory language. They're saying it hasn't been described in the indictment. The statute provided for these punishments for those who conspire to injure, oppress, threaten, or intimidate any citizen with intent to prevent or hinder free exercise, enjoyment, or secured to him by the Constitution or laws of the United States. These counts in the indictment charge, in substance, that the intent in this case was to hinder and prevent these citizens and enjoyment and each, every, all, and singular rights granted to them by the Constitution. There's no specification of any particular right. The language is broad enough to cover it all. So they say that the indictment is unduly vague, doesn't provide enough specificity. In criminal charges prosecuted under the laws of the United States, the accused has the constitutional right to be informed of the nature and cause of the accusation. is an elementary principle of criminal pleading, that where definition of offense, whether it be common law or by statute, includes generic terms, it is not sufficient that the indictment shall charge the offense in the same generic terms as that definition, but must state its species. It must name the particulars. So the statute might cover a lot of ground, which might be fair as to the statute. So we're not saying the statute is unduly vague, right? That just because it's broad doesn't mean it's vague. And people make that mistake all the time. Just because it's broad doesn't mean it's vague. But that being the case, however, if you're going to charge someone with a violation, you can't just recite the broad language back because they don't know what you're talking about. It's like you violated one of these provisions. Well, which one and how? You need to provide more detail, basic who, what, when, where, why, to give them enough information so that you understand what they're talking about. At least according to the Supreme Court, that wasn't done here. It is a crime to steal goods and chattel, but an indictment would be bad that did not specify with some degree of certainty the article stolen. So the law might make it illegal to steal stuff, but you can't just charge someone, you stole stuff. What stuff? From where or from whom? Give me some more information so we know what we're talking about. This because the accused must be advised of the essential particulars of the charge against him, and the court must be able to decide whether the property taken was such to be the subject of a larceny. So too, it is in some states a crime for two or more persons to conspire to cheat and defraud another out of his property, but it's been held that indictment for such offense must contain allegations setting forth the means proposed to accomplish it. So you can't just say you conspire to defraud someone out of property. You have to allege the means used. You have to give them more detail. But it is needless to pursue this argument further. The conclusion is irresistible. These counts are too vague in general. They lack the certainty and precision required by the established rules of criminal pleading. It follows that they are not good and sufficient in law. They are so defective that no judgment of conviction should be pronounced, so the conviction is thus overturned. Thus, that brings us to the end of the case of United States v. Crushank, a case that is somewhat famous for the pronouncement that the Second Amendment is dead, but also, like all the other amendments, are dead, and also more principally because of slaughterhouse cases, that the Privileges or Immunities Clause is dead. So, yeah, the Supreme Court looked at the 14th Amendment and kind of ignored its language, and then went on to ignore it for another 65 years. So, wasn't great times, and that's the history of that. So, I wouldn't really look at this for any reliance whatsoever today, because it's pretty much garbage all the way around. In any case, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.